Hi everyone, this week we are focusing on the question of grievances which are raised on resignation from employment, and particularly where the complaints contained are not actively presented as a formal grievance or using that wording. So many disgruntled employees who hand the notice in also put some concerns, grumbles or sometimes very serious complaints within the letter itself. And many employers will question really what the purpose of investigating those concerns as a formal grievance are in circumstances where there is unlikely to be a resolution other than the employee perhaps seeking some financial recompense. The A-class code is very unclear as to whether the code applies to former employees or those who are about to become former employees. It seems that wasn't the intention, and I don't think tribunals would attach as much weight to an employer's actions in dealing with a grievance once employment had ended. In constructive dismissal cases, for example, an employer's actions are often judged at the point of the alleged fundamental breach of contract, and therefore investigating a grievance after somebody has resigned in response to what they call a fundamental breach of contract seems a little bit pointless and after the event. There are some advantages to dealing with the matter as a grievance, though. It can try to recover the employer's position in some circumstances. So a very detailed investigation could find that the employer had actually acted properly in its view, and if there are substantial grounds to support that conclusion, then that may go some way to defending a constructive dismissal claim in the grand scheme of things. On a practical level as well, detailed findings or the employee realising that they are not, for example, supported in their grievance by colleagues who they may have relied on in their resignation letter could make them think twice about pursuing an argument further. If they realise that the business has interviewed witnesses who are keen on supporting them, they may realise that evidentially they're going to have a challenge in a constructive dismissal argument. And finally, it actually gives the employer an understanding of the risk that it may be taking going forward. So quite genuinely, once they've interviewed a number of individuals and once they've gathered the evidence that relates to the resignation complaint, that should go some way to identifying whether there is actually a feasible case and could shape whether or not there is any negotiation to be had with the employee to try and minimise the risk of a future claim. This will be very fact dependent, so I think what an employer should do on a case-by-case basis is review the content of the resignation letter, review the nature of the complaints, and at the very least, I think, offer an exit interview to the employee so that they can expand on the concerns, and that will give an understanding as to whether they might be agreeable to participating in a more detailed grievance investigation if we feel that's appropriate in the circumstances. If you need any further advice on this issue or anything employment law generally, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.